And the fees under the agreement, the applicant should find basic fee plus supplementary fee. But under the Madrid protocol, the applicant should submit the individual fee also. And the next difference is the time limit specified for examining the trademark by the office of the contracting party. Any provisional refusal must be notified to the International Bureau within the time limit specified in the agreement or protocol. The time limit is generally 12 months under the agreement. But in case the contracting party is designated under the protocol, the time limit should be replaced with 18 months. In addition, the agreement does not provide the option to convert international registrations, which has been centrally attacked, while under the protocol, the international registration can be transformed into a series of applications in each designated jurisdictions. Who may use the Madrid system? A natural person or legal entity which has a real and effective industrial or commercial establishment in, or is domiciled in, or is a national of a country which is a party to the Madrid Agreement or the Madrid Protocol, who has the same condition as in the territory of an intergovernmental organization. There are three kinds of international application. The first one means that all the designations are made under the agreement, and the second means all the designations are made under the protocol. And the third one refers that some of the designations are made under the agreement and some under the protocol. An international registration is equivalent to a bundle of national registrations. From the date of the international registration, or in the case of a contracting party designated subsequently, from the date of the subsequent designation, the protection of the mark in each of the designated countries is the same as if it had been filed directly with the office of that country. If no provisional refusal is notified within the time limit, the protection of the mark in each designated country is the same as if it had been registered as a national registration. An international registration is effective for 10 years. It may be renewed for further periods of 10 years on payment of the renewal fees. The International Bureau sends a reminder to the holder and to his representative 6 months before the renewal is due. The international registration may be renewed in respect of all the designated countries, or in respect of only some of them. It's very flexible. The objectives of the system are twofold. Firstly, it facilitates the obtaining of protection for marks. The registration of a mark in the international register produces the same effect of national registrations. What's more, contracting parties may be designated subsequently. Secondly, since an international registration is equivalent to a bundle of national registrations, the subsequent management of that protection is made much easier. There is only one registration to renew, and changes such as changes in ownership or in the name or address of the holder, or a limitation of the list of goods and services can be recorded in the international register through a single simple step. On the other hand, if it is designed to transfer the registration for only some of the designated countries, or to limit the list of goods and services with respect to only some of the designated countries, the system is flexible enough to accommodate this. Also, here is a table of the advantages of Madrid route comparing with the national route. In basic terms, the primary advantage of the Madrid system is that it allows the trademark owner to obtain trademark protection in any or all member states by filing one application in one jurisdiction with one set of fees, and make any changes and renew registration through a single administrative process. Nevertheless, the Madrid also has some disadvantages. The first one is the limitation of the protected country. Only the party of the Madrid Agreement and our Madrid Protocol can be designated under the international registration system. Although there are more and more jurisdictions join the agreement and protocol, there are still many of the countries are outside of this scope. The second disadvantage is the premise for filing an international application. Under the protocol, the applicant should at least have a pending application, but the agreement requires that the trademark owner already holds an existing registration in the Office of Origin, which may often take many months and sometimes even many years to obtain in the first place. Another disadvantage of Madrid system is that it's called the central attack. That means any refusal, withdrawal, or cancellation of the basic application or basic registration within 5 years of the registration date of international registration will lead to the same effect of the international registration. For example, if a basic application covers clothing, headgear, and footwear, and the footwear is deleted for whatever reason, the international registration will only cover clothing and headgear. The protection afforded by the international registration in each designated country will therefore only extend to clothing and headgear. If the basic application has been rejected as a whole, the international registration will have been totally refused. The process of taking the basic application of basic registration for this purpose is generally known as central attack. Under the Madrid Protocol, the effect of a successful central attack can be mitigated by transforming the international registration into a series of applications in each jurisdiction. This is a process known as transformation. However, the agreement does not provide the transformation process. As far as I know, in 1997, less than half of a percent of international registration were cancelled as a result of the cancel attack.